So I'd like to start by telling you a little bit about the Vidhi Centre for Legal Policy, which is where both Akshat and I work. Vidhi is an independent think tank. We do legal research in areas that we think are critical to reform. We assist central and state governments in drafting legislation, and we do strategic litigation in some select cases. We work across a variety of areas. Akshat and I work specifically in the areas of health, environment, education, gender, and sexuality, and the last of which is going to be what we're talking about today. We have offices in New Delhi and Bangalore. Unfortunately, nothing in Mumbai yet, but that might change if this event goes successfully. Our association with work on LGBT plus rights began in 2016 when we submitted some comments to a parliamentary standing committee on a 2016 draft of the transgender rights bill. 2 years after that, we published a manual called The Law Isn't Straight, which was intended to be a guide to help persons in the LGBT plus community to navigate everyday processes from obtaining identity documents to managing their personal finances to obtaining or changing school leaving certificates. Processes which can be maddeningly frustrating for anyone, but which have a particularly disproportionate impact on the LGBT plus community. In 2019, we published Queering the Law, which is what we're going to be talking about today, and which Akshat will talk to you about in detail in just a minute. Before that, I want to acknowledge the contributions of the people who've worked on these reports, both at Vidhi and outside. So our work at Vidhi was spearheaded by people who were passionate about this issue within the organization and who recognized that this work on LGBT plus rights and inclusion couldn't be confined to a silo, and who came together across different teams at Vidhi to work on these reports. And I think this is a recognition of the fact that this project of queering the law is not solely the responsibility of the LGBT plus community. Instead, it requires all of us, society as a whole, to fundamentally reimagine the law in its application to everyone and to other vulnerable groups in particular, a point I think which is particularly relevant in today's climate, given the kind of threat at which other vulnerable minorities are. So this is what we hope to demonstrate today through our presentation. And for the work that we are presenting today, we are very grateful to Arijit, Arpita, Diksha, Namrata, Nitika, Nivedita, and Shohini, all of whom were at Vidhi and worked on this issue, as well as Danish and Gautaman, who both lawyers and queer rights activists who generously contributed their time in guiding us through these projects. Of course, our work would not exist without the decades of queer activism and advocacy and the personal struggles and sacrifices of countless members of the community that you just witnessed. And we feel privileged to have been able to build on this work in a small way. And we remain committed to doing work to make the law continue to protect the human rights of LGBT plus persons. For our work going forward, we see ourselves not as advocating top-down recommendations or reforms, but instead providing legal support, whether it is through research or legislative drafting assistance, to aid the community in implementing whichever reforms it decides to pursue or to assist it in whatever advocacy campaign that it chooses to launch. And therefore, for us, this talk today is less about a prescriptive set of recommendations, but more about creating an information resource that can facilitate conversations about LGBT plus inclusion. So on that note, I'll ask Akshat to tell you a little bit more about the report.
Yeah, so thank you, Dhvani. So I'll talk about Queering the Law, the project itself. And for us also, it was a journey because we started this project in early 2018 when we realized there was a need to sort of talk more about other legal frameworks because there was anyway enough conversation about NALSA, and then obviously Navtej happened later. And we thought, how can we push the conversation a little? What are the other legal frameworks we can talk about for inclusion? And so when we started this project, it was a completely different exercise. We wanted to identify specific laws which excluded the community, and we wanted to redraft them to make them inclusive for the community. But over time, we realized that that's not the way forward. We had to sort of engage with existing debates, and as Dhwani said, there was a lot of literature already available, a lot of work that was already done. So how could we take all of that, bring all of that together, engage with existing questions, and then produce a resource that the community could use to debate inclusion going forward? And a lot of this project, we'll talk about how we learned what queering would mean, and we would end the presentation by sort of discussing what queering could mean in the future in terms of laws. So what did we do and why, right? So for us, NALSA and NAFTEJ as lawyers was very significant decisions which recognized the rights of the LGBTQ community in terms of their fundamental rights. And what we realized was that they were useful entry points to having larger conversations, because as lawyers, it gave us the space to make arguments for inclusion, how to challenge existing provisions, how to talk about reforming frameworks such as family or reforming frameworks like employment, etc. And a challenge for us was to identify which areas to work in. So as Dhwani pointed out, we worked on a manual called The Law Isn't Straight before this. And we arrived at our categories on finance, health, and education through conversations with community members in Delhi and other organizations. So we sort of took our various categories and we tried to bring them together under these 4 broad heads, which is employment, identity, family, and violence. And then we did a mapping exercise. We looked at litigation in different high courts after NALSA and NAFTEJ to see the kind of cases that were being brought before high courts. And we were really surprised to see that a lot of these cases were by LGBTQ people. They were themselves filing these cases to get their rights recognized before high courts. So we came across cases in the Madras High Court about employment, where people had filed cases to challenge police recruitment forms which did not include the transgender identity. We came across cases in the Himachal Pradesh High Court, where a transgender person challenged succession laws, saying that the Guru Chela tradition had to be recognized in succession. We came across cases in Uttarakhand, where a transgender person said that a trans woman must be part of the provision on rape. You can't exclude me from being a victim of rape just because I'm trans. And that was really interesting because the process of queering had already begun in a sense, because people were filing these cases before high courts. And we sort of mapped them against our themes and realized that these 4 broad themes could be a good starting point to begin with. In terms of the research itself, we looked at existing legal frameworks. We just mapped out laws. We saw like laws within family. We looked at the Special Marriage Act. We looked at existing laws on adoption, on maintenance. In violence, we looked at provisions of the Indian Penal Code. We looked at the workplace harassment laws. Similarly, so we looked at various other frameworks, and we sort of also tried to bring together literature. Because what Kamra is also trying to do, there's a lot of debate that is already there. The women's movement has discussed family law reform since 1990s, and we came across really interesting feminist literature on what some of these way forwards could be for debating family, for debating violence. And we sort of relied on those debates and sort of tried to engage with them to produce to sort of see the law as well as what the debates were and how they could be brought in together to think of a way forward.
Yeah, so there's a lot of sophisticated discourse that's already out
available,
there.
Yeah.
Our job was really to help collate this
curate
and
this together,
put it together and really closely examine the text of the law in a way that we thought might be accessible to a broader audience.
Yeah, and in terms of, so after we did the draft chapters, we sort of organized consultations in Delhi because we realized it is very important to get people in a room and talk about these issues. Because as legal researchers, we end up being very isolated because we work and we do desk research and we write something down. But often that may not correspond to how a person is navigating the law in their real life. So we held consultations in Delhi with community members and with CSOs to sort of discuss our draft chapters. And those were really useful for us because we realized the various limitations in our own project of how we had completely ignored the lived experience of the law, or what are the issues that people are facing on a daily basis. And we integrated those consultation minutes into our reports. So if you look at the end of the reports, there are like points of consideration, which is basically the feedback we received from community members. And we identified some potential way forwards from there that could be either further areas of research or further areas of legal strategy.
And again, we were very lucky today to be able to have similar consultations with people here in Bombay. And we had a very engaging and thoughtful deliberation, and we have even more food for thought now. And these these discussions and the comments that we received will all again be incorporated into our work and disseminated in some form to help us identify common areas of
concern or convergence, and also to help people realize what other conversations happening in other cities, for instance, because we realize often different cities have different conversations. So it might be useful to bring together this content for activists and other CSOs to sort of acquaint themselves with the kind of conversations happening in different parts of the country.
Yeah. So I think now for the rest of the talk, what we're going to do is to present a set of 4 case studies, so hypothetical examples of situations that we think people in the LGBT plus community might face.
Yeah.
And we will present that situation, discuss what the existing position of the law is and how the law might affect how that situation plays out. And then based on that, discuss how we should go about thinking about changing the law to make it more LGBT plus inclusive.
It's our effort to make it slightly more interesting in real life than just talk about bare legal provisions. So Himani is a transgender person who wants to get an identity card as a transgender person to access state welfare services. Before self-identifying themselves as a transgender person, they went by the name of Himanshu and had been assigned the male gender at birth. All their identity cards only recognize this previous identity. Now, how does the law play out, right? So the first question is, which law recognizes the transgender identity, which we all know as NALSA, which says that transgender identity does exist and they have constitutional rights. And now it will be the Transgender Rights Act, which has recently been introduced, which sort of gives legal recognition to this identity. But we all realize that the Transgender Rights Act is hugely problematic because in many ways it dilutes this guarantee of self-identification. Because it may introduce procedures for identifying which were not, so NALSA said that I can claim to be anybody I want to be. I can self-identify as anybody I want to be, and I don't need a medical process. I don't need to prove anything to say who I am. But this new legislation may introduce procedures to prove your own identity, which can be hugely problematic. And what we realized with this legislation as well as other laws was that there was a tension between law and identity. And that's because when we think of identity, we think of it as something fluid. And that's what years of queer theory and gender theory has taught us, right? That identities are not concrete. They can change. They are fluid. But law tends to slot people into categories. And for most of the life of the law, these categories have been male and female. Therefore, most laws themselves are gendered. They only identify male and female. And often laws recognize identities because of welfare benefits. Because if I need to give somebody an welfare, and if I need to give somebody an entitlement, how does the law do it without recognizing them as such? And that's the tension that law faces with identity. How do you deal with fluidity when the law tends to slot you or freeze you as such? And for instance, even the Registration of Births and Deaths Act. So as soon as we are born, we need to get a birth certificate, right? And forms under the Registration of Births and Deaths Act only recognize male and female. So as soon as you're born, you are slotted into a certain category. And this often leads to violence on people's bodies. Because with intersex persons who may not conform to either male or female, this forces them to conform to either of those categories. Doctors often conduct surgeries without the consent of the children or without the consent of anybody to sort of slot them into a certain category. We spoke to doctors in Delhi who told us how there is no protocol for this. Just because they need to ensure that the child is either male or female, they just perform some surgery on the child to ensure that it fits one or the other category. And the law freezes identity like this. In some other jurisdictions, they have processes where you can recognize identity when you're 18. So when you're old enough to identify by a particular gender. Similarly, the language of the law is also often gendered. Now, if you read any law or policy document, it mostly uses the male pronoun. And even the General Clauses Act, which is a legislation to interpret various laws, uses the male pronoun and says the male pronoun includes she. So across our laws, it often uses the word he. And this invisibilizes the trans community.
So, I mean, apart from it being patriarchal, it's still only recognizing two sexes for all practical purposes.
And while you can practically argue that it's a person, and therefore a transgender person should also be part of this law, since he doesn't really mean the male gender, a lot of people don't they just think that's the binary, because people are not aware, or you need to argue with them to say, no, transgender are also persons. And that creates issues. So how do we think about the language of the law?
And there's been around that. So, for example, the National Food Security Act
was challenged in the Allahabad High Court by a transgender person who said that the female head of a household if in a transgender household, who is the female head of a household? Shouldn't a transgender person be recognized as the female head of the household? So these are issues that have come up time and again, and it's illogical to argue that a transgender person is not part of the Food Security Act. But often the language of the law leads to such issues where it leads to litigation, it leads to delays, etc. Similarly, sex and gender, right? So we all understand there's a distinction between sex and gender. NALSA also legally recognized this distinction. But all our laws and policies seem to conflate this. Some will just say sex, some will just say gender, and none of the policies or laws understand this distinction between sex and gender. Again, another issue which we came across was how do rights and liabilities change after a gender change? So for instance, if I'm a man today and I get married and I become a trans woman, I start self-identifying as a trans woman tomorrow, what happens to my marriage? Does it automatically dissolve? How do my rights and liabilities change post-gender transition? And these are some of the issues we generally came across in identity and we thought could be interesting in going forward. Like one broad issue which we realized was just in terms of ungendering language. Do we ungender forms completely? Do we remove gender from all laws so that all laws become neutral in a sense?
That's right.
And yeah.
And so, I mean, when we were thinking about what queering the law means in the context of identity, I think this case study demonstrated that there are three key ways in which the law has a relationship with identity. I mean, first, it dictates which identities are recognized. Second, it dictates, and this is particularly in the context of the Trans Rights Act, which it dictates how these identities must be proved. And finally, it dictates which rights and obligations are dependent on identities. Now, we know that the second of these functions is in the way in which the law controls how you self-identify is plainly a problem. But the first and third are not necessarily problematic of themselves. So, for example, the recognition of a person's identity in the law is a fundamental part of affirming their dignity. And in the same way, the law does have a role to play in recognizing specific identities who require special protection because of various historical forms of oppression or particular social and cultural contexts. So the problem really arises because, as Akshat said, the law has a static conception of identity. It's just our laws and procedures are simply not designed to take into account the fluid manner in which persons identify and express their gender. So when we ask ourselves how to queer the law, again, some answers are obvious. So removing this wholesale reference to the masculine pronoun that the law employs, seems to be a no-brainer. And in this context, I wanted to talk, I've been reading this book called Invisible Women, which talks actually about the gender data gap across various, sections of life, including science and clinical research and literature and media. And the author, Caroline Perez, quotes a poem by Muriel Rukeyser, which is about a blind Oedipus asking the Sphinx, "Why didn't I recognize my mother?" And the Sphinx replies that Oedipus answered her question incorrectly. The question was, what walks on 4 legs in the morning, 2 in the afternoon, and 3 in the evening? And the Sphinx tells Oedipus, "You answered man. You didn't say anything about woman." So Oedipus replies, "Well, when you say man, you include women too. Everyone knows that." Fact is, everyone does not know that, and everyone especially doesn't know that in the context of trans identities or other kinds of gender fluid identities. And therefore, very simply, you can queer the law by changing the way in which we draft legislation. But there are perhaps other questions that require a little more thought. So how do we think about when does specifying gender in a law actually serve a useful role? Yeah. So if I want to open a bank account with the Pradhan Mantri Jan Dhan Yojana, do I need to list my gender? Is the collection of that gender meaningful to the government in any way? And where we recognize that perhaps it is useful, how can the law ensure that it captures the diversity of various gender identities without falling prey to this rigid categorization that has created some of these problems in the first place?
Yeah, so even the Transgender Rights Act in India, right, it focuses on specific identities. If you look at the definition of transgender, it lists a lot of identities there. Instead of focusing on gender identity or gender expression, which has been an approach in some other jurisdictions. So that's also the issue in India, is a lot of these identities are historical, and therefore you need to account for them because they've always existed in the Indian socio-economic context. And that is really the dilemma, because do we do away with identity? If we don't do away with it, where do we keep it and how relevant it is and where it's relevant for us? Now moving on to violence. So our case study is Ravi and Salim met through a dating app and had been regularly meeting for some time. During one of their dates when Salim was slightly inebriated, Ravi forced himself upon Salim. The next day, Salim felt violated and hurt, but was not sure what to do next. Now, this could be a common scenario anywhere, right? And what does a person do after that? So where does the law come in? So how does the law play out, right? So sexual offenses in India under the Indian Penal Code operate in the male-female binary. They only recognize the male as the perpetrator and the female as the victim, and don't recognize any other gender combinations. So what Salim would have to do is go under provisions of the IPC such as hurt or grievous hurt, which are neutral provisions on general physical violence, but do not capture this power dynamic or the power dynamic of sexual violence specifically. So he would have to go under a lesser provision as opposed to sexual violence provisions. And how do we think about violence, right? So when we looked at a lot of these criminal laws, we realized that LGBT plus people are excluded at two levels. One is at the level of language, because it says male, female, so it excludes transgender persons who are not part of the law in any case. Also at the level of the assumptions of the law. A lot of these criminal laws are based on heterosexual assumptions. So if you look at the definition of rape, it requires penetration. Even after the Justice Verma Committee changes to the definition of rape, penetration is still necessary for rape to be proven. But in other contexts, rape may happen in, sexual violence may happen in various other ways, which are not part of the law. And this is not restricted to substantive provisions of the IPC, because criminal law operates at the level of procedure. It operates at the level of evidence. And we need to think about the entire criminal law framework when we think about querying laws relating to violence. Because for instance, even if you are a victim of rape, you go to the police station. Currently, a female police officer has to record your statement. What happens if a gay man goes to a police station? How do you even account for that kind of power dynamic? Who will take the statement? Similarly, under evidence laws, we have a presumption where if a woman says that there is lack of consent, it's presumed there's lack of consent. How do we even translate these presumptions into an LGBT context where power would operate very differently? How would we even, so when we started this process, we started changing these pronouns in these laws. And we realized that's not the answer, because you can't merely change pronouns and come up with an inclusive law. You need to change the assumptions in the way it's drafted to actually queer it. Thirdly, there are contextual provisions. So in India, a lot of the criminal law reform that has happened is due to efforts of the women's movement. And legislation such as the Protection of Violence, Domestic Violence Act is a very good example that accounts for the lived experiences of women in a family setting. Even the remedies that it gives, such as residence orders, maintenance, etc., are contextual to a domestic family. Now, how do you translate something like that to an LGBT context, which might be very different from a heteronormative context of a man-woman family? Another key issue in terms of debates in existing literature was victim neutrality. Now, this has been debated since the 1990s, where the 172nd Law Commission spoke about how we need to come up with a victim-neutral rape law in terms of making it both perpetrator-neutral and victim-neutral. But at that point, the women's movement sort of criticized this recommendation and saying that you can't just change rape provisions overnight. They represent a certain power dynamic. They represent a certain condemnation to an act and recognize a certain social reality. So you can't be unmindful of it and just do away with rape and introduce a completely neutral provision. The debates also happened when the Justice Verma Committee report came out, which is after Nirbhaya's rape case, where Justice Verma Committee recommended a victim-neutral rape law and an offensive sexual assault to include non-penetrative acts. And this is something that has been happening for some time now in terms of how do we think about neutrality. Do we make it victim-neutral? Do we come up with new offenses? Do we retain the offense of rape? Do we come up with new sexual offenses for LGBT people? So how do we think about some of these things?
Or how do we use existing provisions in the law, if at all? So and here perhaps it's important to consider two questions, similar to what we were discussing when we encountered identity. One, does the law recognize the special kind of violence that is perpetrated against LGBT plus persons? And if yes, does it have effective remedies for it?
Yeah.
And This might require us to take a step back and ask why it's important again for the law to recognize and to address or redress different forms and expressions of violence. So, as Akshat mentioned, in a broad and perhaps crude sense, all forms of violence constitute some form of hurt or grievous hurt under the Indian Penal Code. But despite that, the code has specific provisions for sexual violence, and the reason for that is the law is going beyond the mere provision of a remedy. It's calling out a specific kind of violence that it finds particularly abhorrent and is expressly condemning it. Now, this is the way in which the law responds to different kinds of oppressive and predatory behavior in society. This is why we have a special law to address atrocities against members of the scheduled castes and scheduled tribes, or it is why we might have debates about whether we need to introduce a separate provision in our criminal procedure, in our criminal laws for lynching. So these are, as in the expressive function of the law is something to take into account of when considering how to queer it in the context of violence.
And also articulating a theory of power. So in order for law to perform this expressive function, the law needs to understand how power operates. And before we even think about law reform, maybe we need to ask ourselves this question in terms of how power operates and theorize how power would work in LGBT relationships. Because often violence is not just against LGBT people, it may also be within the community. So how do we account for these power differentials in terms of thinking about law reform?
Yeah, and also as in discussed very usefully and people brought up today in the consultation, that it's impossible to think about queering the law in the context of violence and making it work for LGBT plus persons, one, without actually doing a proper empirical research on the different kinds of violence encountered, or and I know that there are already organizations doing that, but perhaps we need to do more of that to be able, or to understand that better before we can recommend a change to the law. And second, again, that this project of queering the law forces us to look at our criminal justice system as a whole, and take a harder look at the justice system, because it's broken for every kind of person, and as a result of that has a disproportionate impact on the LGBT plus community. So it's an exercise that goes to the very heart of our functioning as a rule of law society, and queering the law will not happen unless we look at the criminal justice, fixing this broken criminal justice system holistically. And especially considering the sort of history of persecution and harassment that has been perpetrated on the community by police and state authorities.
So now moving on to family. Anu and Sabha have been partners for 40 years. They have a minor child together, which Anu had legally adopted. Anu recently passed away after a prolonged illness. Sabha was not able to be with her during her last days since her family refused her access to Anu in the hospital. After her death now, Anu's family is threatening to take away the child and the house, since it was Anu's and she died without leaving a will, in which Sabha shared her life with Anu. So how does the law play out in this context, right? Now, same-sex or same-gender relationships are not recognized in India, which just doesn't affect marriage. It affects a bunch of other legal rights and obligations. Now, for instance, an area of concern which we've recently realized is surrogate decision-making. For instance, often in hospitals, the person who can take a decision for you is often your spouse or your family member. And even though that person, you may not be in the best of terms with your family or your natal family, but they are the ones who are recognized as your family. And you might have a partner for 40 years, but she may still be denied access to you in the hospital because you can't prove that relationship. And even right now, in terms of legal frameworks, we don't have a legal framework for surrogate decision making.
Yeah, exactly. So there's actually no real
law.
Certainty about who gets to take decisions about any kind of person towards the end of life, or generally for healthcare decisions.
Yeah.
So I might be a cisgender old man who's estranged from his wife and who's estranged from his son and widowed, and I might still have to have my son come and take decisions for me about when to plug me off, when to unplug the ventilator. So the law is not satisfactory even in the case of heterosexual relationships. So obviously it has, again, even more disproportionate impact on relationships that are not recognized in the eyes of the law.
And it's not just marriage, right? Because it's about adoption. Because since only one person adopted the child, the other person doesn't legally have a right to the child. Similarly, property. How do you deal with questions of succession? Does the same-sex partner get any share in the property? And all of these legal frameworks right now, because often marriage becomes the entry point into these other laws, because marriage is so central to Indian family law that adoption, guardianship, succession, they often revolve around marriage. And therefore, how do you deal with a family law regime that keeps marriage at the center of it? Because since the law doesn't recognize these relationships, it often doesn't recognize these other aspects that come from marriage, as Vidhi pointed out. But often, like in our consultation also, it was suggested how we also need to develop critiques of these frameworks. Because often in popular discourse, we focus a lot on marriage because it seems as the next big step to take. But we often forget that often these frameworks are highly patriarchal and promote stereotypes and unhealthy gender roles. And queer relationships are themselves transgressive, and should they be part of such an existing family law which is not gender just, which doesn't even sort of, is not equal in that sense. And often in the West, there have been debates about assimilationist strategies and radical strategies about whether should just fit people into existing frameworks, or should we rethink of these frameworks? And one of the important points which we realized was for the law to respond to the realities of the community.
Exactly.
How do we keep aspects like caregiving? Yeah. How do we keep other forms of relationships at the center of family law, rather than just focusing on the romantic, monogamous unit? How do we think about alternative families? How do we think about families of choice? And how do we ensure that family law frameworks actually respond to these realities, rather than working in some patriarchal conception of the family which doesn't work for everybody?
Yeah, and I think another point that came out during our consultations in Delhi at least was that apart from this and apart from questioning the structure of recognized relationships themselves, there might still be ways in which to queer the law by using existing provisions creatively. Yeah. So people talked about surrogacy, for example, as a way in which same-sex relationships could create the families of choice that they wanted.
Yeah, but with the surrogacy regulation bill, that becomes a problem.
Exactly, yeah.
So, and how do we recognize relationships of caregiving? How do we recognize relationships that are not romantic or sexual? People might be living together, they might just be codependent or might look after each other and might want to have some rights and obligations as part of that unit. But how does family law even account for such things?
Yeah.
So we need to more critically question existing frameworks before we think of what
and some innovative kinds of relationships like this are recognized in other countries.
Yeah, so for instance, Tasmania has a relationship act where you can just register a domestic relationship. It doesn't have to be a romantic relationship. Similarly, France has its own law on civil.
So it could be two friends living together and deciding to create a mutual set of rights and obligations between themselves, where you are valuing that kind of emotional and economic dependency as opposed to a very specific kind of sexual pleasure that seems to form the basis of marriage in our current legal framework.
So in our Delhi consultation, a lot of people emphasize the need to recognize the values we want to preserve in family law as the community. What are the values we want to focus on? Do we want to focus on sexual pleasure or caregiving or economic dependency? What are the values that are close to us as a community which could then be the building blocks of a potential law for the Lastly, employment. Victor identifies himself as a transgender man. He has been working at a call center for 2 years. In spite of consistent performance, he has been overlooked for promotion and has been limited to routine tasks. When he tried talking to his supervisor, they made sexual overtures. A second sort of hypothetical is, in this situation, consider Victor was a gay man. So how does the law play out? Now, we know that the Supreme Court in both Nalsa and Navtej recognized the right against discrimination, and this is a constitutional right. So technically, all LGBT people have a right to non-discrimination under the Constitution of India. But the real question is, how do you enforce such rights? Every time you're discriminated against, you won't go to the court to file a case. Similarly, the Transgender Rights Act recently has a lot of anti-discrimination guarantees. It lists a number of rights on employment, etc. But it doesn't give you any mechanism to enforce it. It provides for a complaint officer, but doesn't really lay down the powers of the complaint officer. So what you really have are just rights on paper, because you can't effectively and meaningfully enforce these rights. And so while Victor may have these rights, there is no way in which he can there are no meaningful ways for him to enforce these rights. And if Victor was a gay man, then apart from the constitutional right for discrimination, he wouldn't have any statutory right to sort of challenge discrimination on the ground of sexual orientation. Similarly, India's workplace harassment laws, right? They only recognize aggrieved women as a victim of harassment. So while organizations have themselves started neutral workplace harassment policies, because the law doesn't prevent your organization from having one, you can't access statutory remedies because the statute just says aggrieved woman. So it prevents you from accessing remedies outside your workplace in terms of sexual harassment, which is outside the male-female binary. Similarly, so in terms of the larger questions which we came across in this in employment were regarding an anti-discrimination law. And there are already efforts in India to draft an anti-discrimination law. Shashi Tharoor had introduced a bill a couple of years back. Recently, CLPR in Bangalore also came up with its own draft of an equality bill. But how do we ensure that this anti-discrimination law works for everybody and most importantly is implementable? Because just by merely saying that there is a right, it doesn't help you unless there is an enforcement mechanism to implement that right.
Yeah, so we need to do a little more work in thinking about how to give teeth to legislation like that. And also perhaps, I think just to go back to that sexual harassment example, I remember our consultation had concerns about even creating a neutral workplace harassment policy.
Because a lot of people said that the LGBT people will be disproportionately impacted because of how the language of sex is not so, as in, there's no sex positivity in workplaces. So what may be considered as sexual harassment in a male-female binary may not always be sexual harassment in an LGBT context. So you can't have a completely neutral policy without an anti-discrimination policy. Because LGBT people will be unfairly targeted because of being more sex positive, etc. in workplaces.
And so, so primarily for employment, generally, I think when thinking about queering, we think about, again, given that this project is sort of holding up a mirror to society as a whole, perhaps the questions to ask ourselves are how do we create an effective anti-discrimination law? And also what are the steps that the law can take in terms of enabling provisions to provide, in terms of affirmative action or positively promoting inclusion at the workplace? Because apart from discrimination at the workplace itself, access to employment still remains a very major issue. Although I know the Godrej lab, for example, has been working on trans inclusion at the workplace and has a manifesto to that effect, as in these are all policies that are currently operating outside the formal legal framework. So we don't really, the law itself in this case, perhaps we are beginning to realize there may be some limits to what the project of queering can achieve through the text of the law.
And just in terms of, so what does queering the law mean? Through this process, what we realized was that we were focusing too much on the text of the law and the substance of the legal framework, which often may not be the object of querying at all, because it often goes way beyond that. It often goes, as in, even though you may change the law, it may not affect a person's life on the ground, because they're in their interaction with the state, in their interaction with the instruments of the state, they may still feel discriminated, or they may not be able to access the law. So what we realized, or what we thought of with probably three components of querying was the process of lawmaking, the substance of the law, and implementation and enforcement. And I think to begin with process, and the best example is the Transgender Rights Act, which was enacted without any proper consultations, and which has resulted in provisions that are very theoretical. They don't represent the realities of the community on the ground. So you need to ensure that when you draft laws, you need to be consultative. You need to talk to as many people as possible to ensure that lawmaking actually reflects the realities of the people that it seeks to protect.
And again, this is true for all kinds of laws, but obviously holds special relevance in the context of the LGBT plus and generally other rights-based legislation as well.
Then in just in terms of the substance of the law, how do you, that's obviously what most of our project focused on, in terms of how do we ensure that the text of the law then responds to these realities? How do we actually queer it to make it work? How do we draft it well? How do we ensure that it's practical and not theoretical? So, and the last point was implementation and enforcement.
And I think this was again a point that came up quite a lot in the consultations today, and specifically in the sense of sensitization of the state authorities, the police, government officials, bureaucrats who will be making these provisions of the law actually work. So unless there is that kind of sensitization. Even having the most well-intentioned law, might not help things change on the ground at all.
Yeah.
And so we think of queering in these three buckets. We are obviously concerned primarily with the second one, although we are hoping to do that by being consultative through the first process. As I mentioned in the beginning, we are very open to receiving any comments or critiques on the reports, which are all publicly available on our website. And we do hope you write in to us with any questions that you might have, any suggestions you might have, or any experiences that you might want to share with us. Thank you very much.